Imagine you marry the love of your life, and then the government hands you a stack of paperwork thicker than a wedding album. That stack has a name, and one of the most important pages in it is called the I-130. The I-130 is officially called a petition for alien relative, which sounds like you're filing paperwork for someone from another galaxy. But really, it's just the form a United States citizen or green card holder files to say, "Hey government, this person is my family, please let them in." Here's the thing though, filing the I-130 is not the same as getting a visa, and this is where a lot of people get confused. Think of it like buying a concert ticket versus actually getting through the door. The petition just gets you in line. Now, spousal immigration cases are theoretically one of the faster categories, especially if you're a US citizen sponsoring your husband or wife. But faster in immigration terms can still mean months or even years, so buckle up because this is not a Netflix show that drops all at once. Here's where it gets really interesting. What happens when your spouse has something in their immigration history that could get them rejected? Maybe they entered the country without permission, overstayed a visa, or have a prior removal order hiding in their past like a bad Yelp review. That's exactly when something called a waiver enters the picture, and no, not the kind you sign before going ziplining. A waiver in immigration law is basically a formal request asking the government to overlook a specific problem in your spouse's history so they can still get their visa. The most common one you'll hear about in spousal cases is the I-601A, which is the Provisional Unlawful Presence Waiver. This one is specifically for people who lived in the US without legal status and need to leave the country to attend their visa interview, but are terrified they'll be stuck outside for 3 or 10 years due to something called an unlawful presence bar. See, U.S. immigration law has this rule that says if you were in the country without permission for more than 180 days, you can be barred from returning for 3 years, and if it was more than 1 year, that bar stretches to 10 years. The I-601A waiver lets your spouse apply to have that penalty forgiven before they even leave the country, which is a huge deal. To get that waiver approved, your spouse has to prove that their absence would cause extreme hardship to you, the U.S. citizen or permanent resident spouse. And just so we're clear, extreme hardship does not mean you'd be sad or that you'd have to learn how to cook for yourself. The bar is genuinely high and requires real documentation. We're talking financial records, medical evidence, country condition reports, and deeply personal statements that explain why separation would be devastating in ways that go beyond ordinary difficulty. Immigration lawyers earn their fees here because building a convincing extreme hardship argument is part legal brief, part emotional storytelling, and 100% high stakes. There's also the older I-601 waiver, which covers a broader range of grounds of inadmissibility beyond just unlawful presence, things like certain health-related issues or specific criminal history. That one is filed after a visa denial rather than before the interview, making it a kind of okay, that didn't go well, now what option? What a lot of couples don't realize is that not every problem requires a waiver, and not every waiver will be approved, which is why talking to an immigration attorney before you do anything is genuinely the move. Going in without professional guidance is a little like performing your own dental work, technically possible, deeply unwise. The stakes in these cases are real because getting the strategy wrong can mean years of separation, wasted application fees, or worse, a permanent bar. An experienced immigration lawyer looks at your spouse's full history, identifies exactly which waivers apply, and helps you build the strongest possible case from day one. The I-130 and waivers are not the finish line. They're more like the opening chapters of a very long book that hopefully ends with your family together. Understanding what each piece does, and when it's needed, gives you the clarity to move through the process without blind panic. If you want to learn more about how our team helps families navigate spousal immigration from petition to approval, are you ready to check out our links in the description?